This is Michael Popok. It's time for, Legal AF After Dark, the case for election interference in the District of Columbia against Donald Trump on 4 counts is on its way back to Judge Chutkan as we speak. She's going to be convening a hearing along with all the lawyers on the Department of Justice Special Counsel side, on the Trump side, to talk about procedures, logistics, and a potential mini trial, evidentiary trial that she's now going to have to conduct as commanded by her bosses at the United States Supreme Court in the 6-3 MAGA majority that are going to require her with a fine-tooth comb to go through the entire 45-page indictment of Donald Trump and figure out which is core presidential powers. There's about 7 of them that would give Donald Trump complete, absolute immunity to prosecution, which are official conduct to its outer boundaries, which would give him a presumption of immunity that could be overcome by the prosecutors under certain circumstances, and which fall into the very small bucket of unofficial conduct for which there is no immunity, but there are prosecutable crimes. Confused? You won't be after you listen to the most recent episode of Legal AF. Take a listen.
But the part about this decision that to me takes the cake is that you're not allowed to even look at the motive, and you're not allowed to use any evidence. And that's the part that could potentially impact the Manhattan DA case. But that's what surprised me. But to answer the question, what happens next? What has to happen next is this case is being sent back down to the district court, where Judge Chutkan now has to hold a hearing, which Danya Perry, my colleague in law and in podcasting on our other podcast, Mistrial, she said a couple weeks ago, she said that she predicted this. She said, okay, even though clearly we're not going to have a trial in this case, we could have what she called like a mini trial, meaning a hearing to determine what is official and what's unofficial. She, I think, predicted that this was going to be the direction they went, certainly not as far as they went, right? She didn't think they would go so far as to even talk about evidence. You can't even use evidence to prove other things in your case, if it involves anything involving his core powers. But this mini hearing or trial, if you will, if I were Jack Smith, I think the way I'd be thinking this through is I would put on my whole case, everything. I'd want a record. I'd want the judge to make a record of what's core presidential responsibilities, what's presumptive, what's in, what's out, essentially what's official conduct and what's unofficial conduct. Because if it's unofficial conduct, it comes in. If it's official conduct, it's out. That's it. And so I think that they should go through every piece of evidence and every witness and put the whole case on. And the good news is, what that does is that gives us a preview of what the evidence is. Now, Judge Chutkan might preclude Jack Smith from putting on the DOJ piece of his trial because the Supreme Court has already ruled that that is clearly core presidential conduct or duties, and therefore is out. So there is a chance we won't get to see that. We'll only get to see the part about what could go either way. So that's what's going to happen. The other thing that the Supreme Court in this decision said in a footnote that Judge Chutkan has to do is also analyze the Fisher case that also came down this term recently that talks about whether obstruction of an official proceeding, the charge that two of the charges against Donald Trump and the charge that has been utilized in many of the January 6th cases, whether their decision about what needs to happen in order for that statute to stand. It's not okay to obstruct an official proceeding, for example, by breaking and entering. It has to be, you have to like rip up a document. It has to be involved. You have to involve something tangible like a document. So I think that's the other thing she's going to have to determine is how, because he's charged with 4 counts, 2 of them are obstruction of an official proceeding. In that case, she's going to have to make that determination as well during this hearing.
Well, that's a good breakdown. I mean, the way I've told people, it's a waterfall. Core constitutional powers, which are literally expressed in the Constitution itself. War powers, commander in chief. That's where the SEAL Team 6 stuff comes from. and some other executive branch function that is literally spelled out as an Article 2 power, absolute immunity. And what you throw into that bucket is going to now be up to Judge Chutkan, although, as you said, the Supreme Court has decided at least one of them in advance that she doesn't have to decide, which is his interaction with the acting Attorney General, Jeffrey Rosen, and with Jeff Clark and all that weaponization of the Justice Department. That's out. Things that are official conduct and the outer perimeters of that under the Blassingame case and other cases, that's going to get an immunity, and unless, not absolute though, unless the government, the DOJ, is able to overcome the presumption by showing that the prosecution would not improperly interfere with presidential authority or power. Which I think in some of the examples that we've been throwing around about crimes and go kill my opponent, I think they would overcome the presumption. So I'm a little less.
Let's play that out. Okay.
Sure.
So Donald Trump walks up to Jeffrey Clark and says, Donald Trump appoints Jeffrey Clark to be Attorney General of the United States. Yeah. Okay. And he says, I want you to go kill my opponent.
Yeah, I don't think that works. I don't think that even though on first blush it falls into some sort of absolute or rebuttable presumption, I think that he has gone beyond what is within the canon of the core conduct to order something that the founding fathers, the framers of the Constitution, never would have envisioned, is that he would be a murderous president. And I think even this Supreme Court, if somebody tried that, hey, let's try this. It's an owner's manual. Let me try to kill my opponent, or give an order to kill the campaign manager for my opponent, or wiretap the Democratic National Committee, like in Watergate. See, I think that whole.
I don't think they're even allowed to look at it. They're not, because you're not allowed to look at motive. You're not allowed to look at motive. It specifically says that.
You're not allowed to look at motive, but you are allowed to look at the crime being inside, or the alleged act being inside or outside core conduct. You don't have to get to motive. There is no way the United States Supreme Court is going to allow a president to push the button to kill an opponent. I know we like talking about it that way because it's very interesting, but it's not going to happen because they're not going to find that that's core conduct.
But Sonia Sotomayor put that in her dissent, and Justice
I don't agree with it. I don't agree with it.
But but she said, who's a member of the United States Supreme Court, said,
she is, in dissent,
said that conduct would be immune, and Justice Roberts did not disagree with her.
You don't have to, but that's not how Supreme Court rulings work. You don't have to disagree with every aspect of dissents and to say, well, no, that just like the majority opinion didn't adopt Clarence Thomas's special counsel is improper. So it's not always call and response in majority opinions by the United States Supreme Court. If they had a problem with it, there are some places where they get wounded and they're like, oh, I better take on the prosecution. I better take on the dissent. I'll be frank. I know Ben has said it too. I just don't see it. I see where there are certain things in his core powers that they're not going to allow you to touch. And yes, motive is one of them, and you can't put on evidence of official conduct to prove unofficial conduct. I get all of that, but they're not. They haven't, in my view, they haven't created a Leviathan, out of control imperial president who can commit murder on domestic soil and get away with it I just don't see that. I'll be honest with you. I just don't. Plus, as I did at a recent hot take, he would be impeached and convicted by the House and the Senate, which is the ultimate check and balance on the president, and removed from office. Whether or not it is an immune crime or not, the analysis of high crimes and misdemeanors, which starts from 1368 in Britain, and which was adopted by the framers of the founding fathers, says it's not a crime on the books. And as Justice Roberts said in this decision, impeachment is a political process. You don't look to the statute books to see if the crime happened or if there's even a crime that matches. Abuse of power, maladministration, abuse of public trust is all high crimes and misdemeanors. So that guy that you just described, or woman or whoever it is, it ends up being removed from office. And then it's going to be up to a court to determine if the kill order is a core presidential function as outlined by Justice Roberts in this opinion.
See, I just see it totally differently.
I know you do. That's what makes for a fun show.
They don't get to high crime or misdemeanor because it's not a crime. He's immune.
No. But that's not the way high crime and misdemeanors ever been used.
And not only that, look what happened Jan 6. They didn't convict him. Right? He was impeached and not convicted. You think you can trust the political process in this divided world?
Well, let me unpack that.
Okay, go ahead.
Let me unpack that. High crimes and misdemeanors historically for the last 400 years has never meant an actual crime on the books. And it doesn't matter whether you have immunity. And I think Roberts recognized that when he said it's a political process and we're not touching the political process. See, Trump tried to argue you have to go through immunity, you have to go through impeachment in order to come out the other side to a prosecution. And Roberts said, no, you don't. That's a political process for removal, which is the penalty for impeachment and conviction. Now, whether you can get a majority of Senate to recognize a murderous president, I guess that'll have to be left for another day. Hopefully not. But I don't think it's going to fall into core from the text of the Constitution, absolute immunity. Maybe it falls into rebuttable presumption official conduct. And then I think the prosecution is able to rebut the presumption by showing having a murderous president, if this is going to be our continued example, is outside the outer boundaries of official conduct and is not something that interferes with the normal operation of the executive branch. See, that's where I come out differently. Although I think it's fun to talk about the killer president.
I don't know. It's interesting, and I think I love that you have a different take because,
of course,
but I don't see it even remotely. I really see this.
You think there could be a killer president that the Supreme Court will ultimately say, yeah, that's fine. It was core presidential power.
He's going to say, you can't even look at it. He's not going to just go out and shoot someone, right? He's going to go out and he's going to, let's say he's going to order an investigation into his rivals.
How about he pulls, I'll give you your example. He pulls the Secret Service detail for Biden if Biden loses and Biden gets assassinated. How about that? Is that okay?
I think he's immune.
Okay, I don't think he is. I don't think you can pull the Secret Service detail, but we'll see. Hopefully we'll never have to see. The problem that you and I are demonstrating by this debate, which is good because we always say in our notes we're debating, is the problem with it is that this decision is so opaque as to how human beings in trial courts are supposed to apply it to conduct that it's going to be a tremendous Herculean task, for Chutkan through this mini trial. I agree with you. And I agree with you that she's not going to be able to they're not going to be able to put on evidence related to the Department of Justice. But at the top, when I turned it to you, I said, what do you think's left? I think there's a lot of the indictment and the 4 counts of the indictment left over that will be able to be, the evidence will come out this way before the election. And then there'll be a trial, which hopefully will happen. I don't know. I mean, it may not be November. It could be November, December, January. Somewhere in there by that point. However,
you don't think that he can? So this is another question. Let's say she has the hearing and she rules certain things are in and certain things are out.
She will.
You don't think he can appeal before trial?
No, I do. Yeah. I do. And there may be, I don't know if there'll be another stay of it. And then Roberts, who wrote the opinion, is going to be the first judge to get it on the appeal. First, it'll go to the DC Court of Appeals. And there's going to be a whole delay thing. And that's part of the calculus. That's why I know people are like, try the case. I'm not sure, the timing of all these appeals is going to actually come out. If you and I were talking about this 2 years ago, I feel a lot better. On obstruction, in the concurrence, Ketanji Brown Jackson gives the way to thread the needle and to say that the integrity of the certification process was impaired by Donald Trump's conduct and the use of false evidence, which is in the majority opinion in Fisher, I think salvages the claims against Donald Trump. And as you said, she's been directed to apply that as well. But that's another appeal processes delay thing. I mean, this is why back to Merrick Garland, if he had just not wasted a year to appoint a special counsel and just did it himself with Maine justice, we wouldn't be in this mess. Welcome back. That was Legal AF. We do it on Wednesdays and Saturdays at 8 p.m. Eastern Time. On Wednesdays, it's Karen Friedman, Agnifilo, and me. On Saturdays, it's co-founder Ben Meiselas and me. And then we do it on audio podcast platforms of your choice. We curate the top 4 or 5 stories at the intersection of law and politics, and we do it the only way we know how. No smoke, no sunshine, unfiltered, not censored, unplugged, whatever you want to call it. It's the only way we know how to do it. No one tells us what to say on the show. There's no censorship. This is our observations as practitioners of Supreme Court law, trial law, criminal law, civil law, state and federal, lawyers who know what they're talking about at the intersection of law and politics. We bring it to you right here on the MeidasTouch Network. Free subscribe. Yep, I said free. Help them get to 3 million before the next election. We're building this network with our bare hands, no outside investors. And the way we do it is to get as many subscribers as we can to join our audience. So we invite you to do that. If you know all about Legal AF and you're already part of our audience, we really thank you from the bottom of our heart for being here. We can't express enough how important you are to us, and hopefully vice versa. If you don't know what I'm talking about, or even if you, let me back up. If you know Legal AF, to help us get a bigger audience, send that clip off, like a bite-sized version of Legal AF, and ask friends and family, people in your life to join us. If you don't know about Legal AF or that particular piece of content here on the MeidasTouch Network, that was a clip. We invite you to join us Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on the MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary. Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.